Hello, I'm David Barlow. I'm a car accident lawyer here in Honolulu, Hawaii. And today we're going to talk about a couple of ways that you could lose your case. We spend a lot of time on our website discussing ways you could win your case or get a better settlement offer. But today we're going to talk about two ways you could lose your case, obviously, so that we can try to avoid that and get you a great settlement. So again, this will be on the web page. Some of the ways you could lose your case. You click on the free advice link at the top, and it's right there near the top of that list of web pages. So the first way you could lose your case, it says number one, you don't reach the tort threshold. Obviously, that is some lawyer lingo right there. The tort threshold is what is referred to in the legal community. Tort is, of course, a wrong in the civil arena. So think of it like a crime is doing something wrong in the criminal arena, like you broke a criminal law and you're going to be prosecuted. A tort is something wrong that you do civilly. So like negligence to cause an accident is a tort. And there's obviously a lot of other torts. So the tort threshold is what we refer to it as, in that there's this threshold, which means you have to have $5,000 in medical bills paid by your no-fault insurance. And so this $5,000, that's referred to as the tort threshold. This is probably the only place I'm going to talk like this, because usually with my clients, I don't really even use these terms. I just tell them you need $5,000 in bills paid by your no-fault insurance. That is the tort threshold. That is a Hawaii law. The law basically says if you don't have $5,000 paid by your no-fault insurance, and we don't think you were seriously injured and you cannot go to court. And so if you can't go to court, then obviously you can't get a settlement, because that's the only reason why insurance companies settle cases, is because they don't want to go to court. So if you can't go, then they just say, sorry, we're offering you zero. They don't usually even offer an amount just to be nice. They just say, nope, you didn't meet the threshold and we're denying your claim. So the bottom line is your no-fault insurance. You can read a lot about that on our webpage as well. That is the insurance for the car that you're in. In Hawaii, the Hawaii law requires that you have $10,000 in medical coverage on your own insurance. So your own insurance is going to be paying your medical bills. Again, we talk about that a lot on other pages about how that's a little bit, doesn't quite make sense at first. But you can read about that more on other pages. So you do have to have $5,000 paid by your no-fault insurance, not by your personal insurance, unless you don't have no-fault insurance. So motorcycles are not required to have no-fault insurance. So if they get in an accident, it's $5,000 paid by the personal insurance. I guess I should have to research if you don't have personal insurance or no-fault insurance. It may actually just be the medical bills. But if you have no-fault insurance, they have to pay the $5,000. So if all the bills are paid by your personal health insurance, you did not meet the tort threshold. Obviously, that can be fixed. Hopefully, it's more difficult to fix it after the fact. It's better to just make sure right from the beginning that your no-fault insurance is paying your medical bills. So you need to tell your medical provider right off the bat, tell the ER at the hospital right off the bat, I got in an accident, I'm going to be providing you with the no-fault insurance now or later. Obviously, you probably won't have the claim number at that time, but at least you'll know your own insurance. You can go in and say, oh, I have Geico insurance. Make sure you send the bills to them. I'll give you the claim number later. So it helps to just do it right from the beginning, because when we don't catch this right at the beginning and personal health insurance pays, then we got to go around and try to fix it. We tell the health insurance or the medical provider, hey, you should have been paid by the no-fault. You need to send the bills to the no-fault insurance, and when you get paid, you give the money back to the personal insurance. So it's a little messier. It's much better to catch it from the beginning. So, that's kind of assuming you have 5,000 in bills. A way that you lose your case is you never have 5,000 in bills. This is kind of common, especially if people don't go to the emergency room. All right, if you go to the emergency room and they do even a few tests, you're probably up to already a few $1,000s in medical bills. If they do a bunch of tests, you're probably 5, 10, or 1,000 or more in medical bills on the first day. And obviously the tort threshold isn't even going to be an issue at all. But this is an issue, especially if people don't go to the ER. Sometimes even if they do go to the ER, they didn't do a lot of tests, they have a $2,000 bill, and then they don't get much follow-up treatment, then they don't reach tort either. So this is the number one question we always have in our minds when new clients call us. It's, all right, are they going to reach the tort threshold? They call and say, oh God, it was a really bad accident. They rushed me to the ER in an ambulance. So I'm thinking ambulance, okay, that's $1,200. ER Queens, they're pretty expensive. It's a couple thousand just to walk in the door. And then they say, oh, then they did like 10 x-rays, 2 CT scans. I already know, okay, we met the threshold and it's not an issue. But it does get a little concerning when they either didn't get much treatment at the ER, or it was a cheaper ER, or they don't get a lot of follow-up treatment. So, if you did go, ideally the perfect case, assuming it's not really serious injuries, you go to the ER, you have a few thousand in medical bills, but then you still have like 7,000 left in no-fault insurance that you can get all kinds of follow-up treatment for that isn't usually paid by your personal health insurance, like chiropractor, massage, physical therapy, acupuncture. All this is paid by your no-fault insurance, and a lot of it is not usually paid by your personal insurance. So it's kind of nice if people try to work this out perfectly, where they don't spend a lot of the ER and then they have plenty of money left for the follow-up treatment. The important thing is to actually get that follow-up treatment. All right, make sure, especially if you know the ER bill was only a couple thousand, make sure you really take all this follow-up treatment seriously. So the way going back to the title, the way you could lose a case, to be honest, we've had cases that were $10, $20 short of the $5,000 threshold, and the case was dead at that point. Of course, we do everything we can to get them to get more treatment, to get more bills. But if the client's kind of like, I'm done with treatment, I'm not going to worry about it, then we tell them, okay, well, then your case is closed. We cannot get you a settlement. So literally, we have had cases that were like $10, $20 short. And, 10 years ago when I was new, I would kind of beg the adjuster, come on, they're so close. But now I know better. Now I know the adjuster's like, oh, this is perfect. We don't have to pay him anything. I've had some pretty bad accidents, and somehow the ER bill wasn't, very big. They didn't get hardly any follow-up treatment. They were $50 short, and it's just like amazing. If you saw the damage to the car, you would be shocked that they didn't reach the threshold. But it happens. That's why we're doing this video today, because it's something you got to think about and be aware of. All right. So, and there are a lot of tricks to it. Just because you went to the ER and did a lot of exams doesn't necessarily mean the no-fault insurance is going to pay the full amount either. If they think the ER is inflating their bills and just trying to take advantage, because let's face it, everybody knows, oh, he got in an accident, he has $10,000 in benefits. Some medical providers try to take advantage of that, and they can't really do that for massage therapy, well, especially for like chiropractor. That's limited under the law to $75 per visit, up to 30 visits. So people, sometimes clients will go back to California where they don't know the law, and these chiropractors try to bill $200 per visit, and then they only get paid $75. So different things like that can make it a little tricky. But just to move on, the second way you could lose your case is to have extensive medical liens on your case. Medical liens, is when a medical provider, for one reason or another, they didn't get paid, so they put a lien on their case, or some providers, some insurance companies want to be reimbursed from what they paid. Again, the injury lawyers are fighting this, and we have some good case law on our side, but even though the law is kind of on our side right now for most situations, not every single situation, of course the insurance companies are not taking that really well, and they're still fighting it and trying to get reimbursed. Of course, there's some what we call super liens. This is Medicare or TRICARE or Quest, DHS for Hawaii. Under the law, they're entitled to be reimbursed. That can really hold up a case, especially if they put a notice to the insurance adjuster that there's this lien, then the insurance adjuster will refuse to settle unless they can send a check directly to that lien holder when the case settles, different things like that. So these liens, especially when they're big amounts, they can really hold up settlements or even almost ruin a case. For example, if the policy limits for the person that hit you is only $20,000, but then for some reason you get, $15,000 in treatment and paid by Medicare. Medicare wants to be reimbursed at $15,000, but there's only $20,000 in insurance. Of course, you got to pay your lawyer and all that, and maybe you have other medical bills, and so it's almost like the case is lost because there's really no way to really, end up getting you compensation. Obviously, with a lawyer, we'll fight to get the liens down, and especially situations like that where there is a policy limits issue, we are pretty good at getting everyone to cooperate. But once in a while, you get a lien holder that won't cooperate. They say, we want that $15,000 no matter what. We tell them, well, the case won't settle, and okay, we don't care because we don't negotiate or whatever it is. So that's another way that a case can be ruined. Obviously, if you have a good lawyer, we can, try to work around these two ways that cases can be ruined. And we'll do our best. It's not always 100% possible to help a case that has been ruined by one of these ways. But obviously your odds, if you hire a lawyer, is much higher in trying to figure this out than if you don't. So that wraps us up. If you have any questions, feel free to give me a call. We always offer free consultations, and we're always happy to help the people out who've been injured. All right, thank you for your time, and have a great day.